administrative law. So you can just say it is law relating to public administration. 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 So how there's actually what we call administration in the public. How is it actually supposed to happen? So it basically sets the guidelines. This particular law sets the guidelines as to how the public should actually be administered. And in this case, for example, you are focusing on those people who are actually basically given the mandate to be involved in administration. Let's say, for example, the executive or the government, or how are they actually supposed to carry out themselves. So they'll basically be held responsible under what we call administrative law. So they have a role to play to the members of the public. So if they fail to basically fulfill that particular role, so the law that basically will make them become accountable or culpable, then it's basically known as the administrative law. So it is basically related, it is actually related to what we call public administration. So how the public should actually be administered, So you can simply just be able to mention and say it will involve laws relating to performance. It will involve laws relating to performance. It will involve laws relating to performance, management, and execution of public affairs and duties of public affairs and duties. So it will basically be able to clearly indicate what are the requirements in terms of performance and the duties of the those who are actually basically in administration. So we've clearly mentioned, especially the government, how it's supposed to carry out its functions, how it's actually supposed to carry out its functions. So it'll basically be, it will involve, like, for example, establishment of public bodies that are supposed to carry out administration. Let's say, for example, maybe the city council, establishment of public organs and bodies. Let's say, for example, parastatals, which are supposed to provide certain essential services to the citizens. So any law that actually basically deals with such, then it will basically be categorized under administrative law, because it is basically giving the functions and what are the requirements in terms of performance of those particular offices, So if they fail to perform, then they can be held responsible under what you are calling administrative law, So what are the main functions? When we talk about administration? So the administrative functions will include, you can just say the administrative functions will include ministerial functions, will include ministerial functions, administrative functions, legislative functions, administrative functions, We have judicial functions, judicial functions, judicial functions. So these are basically some of the major functions when you talk about administrative functions where the law will actually be applied. So in the government ministries, so in this case, we are talking, for example, IE. So you can put here administrative functions. You can say in government organs, or can say parastatals in government organs, or parastatals, government organs or parastatals. For example, the Kenya Revenue Authority, Kenya Ports Authority. So those are the parastatals we are talking about. They have been given a mandate to be able to fulfill for the citizens of the country in terms of carrying out certain administrative functions. So we can actually be able to categorize them here. For example, in this case, we've talked about the Kenya Police. So they have a mandate to fulfill certain administrative functions. So they can be categorized also, those persons who are basically carrying out administrative functions. So these are the functions that basically where this particular law will actually be applied. So it will clearly give guidelines as to how they're supposed to carry out themselves. So any law that basically tackles such kind of matters will actually be categorized under what we call administrative functions, So then we can just say this particular law is actually very important because it ensures proper dispensation of services. So it basically ensures that, for example, the ministries are actually administering or basically giving out their services as required, as per the required standards, or basically as per the set standards. Then it will actually also be able to protect citizens against maybe abuse. So abuse of power. So it avoids or basically leads to avoidance of what we call abuse of power. So those given the mandate to hold those offices won't abuse their powers because the law is actually there to be able to check on what they are doing or check on the balances in terms of the powers those officers have been given. The officers the officers will actually be able to perform their functions as per the powers given under the law. So what are the importance? So you can say the importance of administrative law is to ensure the importance of administrative law is to ensure the importance of administrative law is to ensure the importance of administrative law, the importance of administrative law is to ensure number one, you can write and say to ensure proper dispensation of services, proper dispensation of services. Number two, to ensure proper dispensation of services. Number two, to protect citizens from abuse of power, to protect citizens from abuse of power, protect citizens from abuse of power, then to keep the powers of government, and various public bodies within their legal bounds. To keep the powers of government, to keep the powers of government, within their legal bounds, Keep the government within their legal bounds, So those are some of the importances or reasons as to why this particular law is actually important. So I want us to look at something known as the doctrine of separation of powers. So since we're talking about government agencies or basically departments of government, so there's something known as the doctrine of separation of powers. So the doctrine of separation of powers. So it is a principle that was actually developed by a French jurist. So a French jurist, so he basically argued or basically stated that for government to be able to function properly or its powers to be checked properly, then it must be divided into three. So that particular experts basically stated that for the powers of the government to be properly in check, then the powers must be divided, or basically the functions of government must be divided into three. So that is what was actually stated under this particular doctrine called the doctrine of separation of powers. The doctrine of separation of powers. The doctrine of separation of powers. You can just say it is a principle that was developed by a French jurist. It is a principle. A jurist is an expert in law. It is a principle that was developed by a French jurist. A French jurist. A jurist is an expert in law. A French jurist that was developed by a French jurist known as Montesquieu. Montesquieu. So it is actually developed by this particular French jurist or French law expert known as Montesquieu. Whose concern, you can say whose concern was the overconcentration whose concern was the overconcentration of governmental powers in the hands of one person, in the hands of one person or body, in the hands of one person or body. So this guy basically realized that if we give government powers to one person, then basically there can be what we call abuse of power. So in this case, you can assume, for example, here in Kenya, if all the powers of government were given to the executive or the office of the president, whereby the president is actually one who makes the laws, is the one who basically implements the laws, is the one basically who carries out judicial services in terms of making rulings or judgments. So you can maybe imagine how those particular powers can actually basically be abused or misused. So to avoid such, this particular guy actually proposed that for a proper functioning government to be in place, the government must actually basically be divided into three arms of government. So that is basically the legislature, the judiciary, and the executive. So that is basically was the major characteristic of this particular doctrine that was developed by this guy known as Montesquieu. So actually this one is actually basically one of the major characteristic of constitutionalism, that in that this principle has actually basically been adapted by most countries around the world, such that they normally divide their government into those particular arms of government. Like here in Kenya, we have the legislature, we have the executive, and we have the judiciary. Actually, to this guy, his main aim was actually basically for these particular arms of government to be completely separate. So he wanted them basically to be completely separate, such that the legislature does not actually depend on the executive, but it can actually be able to oversee or basically check what the executive is actually doing. The judiciary shouldn't actually be able to depend on the executive, but it should actually be able to maybe try to check also what the executive and the legislature are actually carrying out. So this means that, for example, if the executive has made a wrong, it simply means that the judiciary is actually there to be able to correct the wrong, or maybe point out that a particular wrong has actually been done by the other arm of government. But according to his argument, these particular arms of government cannot actually operate in what we call a glass ceiling. So a glass ceiling, they can't be completely separate. There has to be some form of interdependence. For example, in this case, the judiciary will basically depend on funding from the executive to carry out its activities. So it has to get a funding or a budgetary allocation from the executive and the legislature. So somehow these particular arms of government, there'll be some form of interdependence, but the main aim is actually basically for their powers to be separated such that one arm of government can actually be able to oversee or check on what the other arm of government is actually trying to do. So you can simply be able to say that this guy, he suggested, so his suggestion was, then you just put a semicolon, he suggested put a semicolon. There should be different organs of government. There should be different, number one, there should be different organs of government. There should be different organs of government. There should be different organs of government, i.e., that is, we mean the legislature, that is, we mean the legislature, the judiciary, and the executive. The legislature, the judiciary, and the executive. The judiciary and the executive. The judiciary, and the executive. The judiciary and the executive. The legislature, the judiciary, 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 and the executive. Then his other proposal, the different organs of government should basically exercise different functions. So the organs, the different organs should, you can say the different organs his second proposal, the different organs must exercise different powers, must exercise different powers, So the different organs must actually be able to exercise different powers. So must exercise different powers. So the different organs must exercise different powers. So they must exercise different powers. His other proposal was that number 3, so no person should be a member of more than one organ. So that was actually also his other proposal. So no person should be a member of more than one organ. So no person should be a member of more than one organ. No person should actually be a member of more than one organ. Should be a member of more than one organ. So no person should be a member of more than one organ. So that was actually his proposal, but that one does not actually happen in reality. So you might find that a person is actually basically like in more than one arm of government in our current situation. But that was actually basically his main aim. So if you're actually in government, or basically you're actually in the executive, you shouldn't actually be in the legislature. So that was actually basically his main aim. So his emphasis was actually also on the aspect of the independence of the judiciary. So he really wanted the judiciary to be very independent, because that is basically the major arm of government that has to ensure checks and balances in terms of the powers practiced by basically the powers that are been given to maybe the legislature and the executive. So so independence of the judiciary was actually one of these. It was actually the integral part of the doctrine of separation of powers developed by Montesquieu. So the integral part was actually basically to ensure also, mostly, there's actually basically what we call the independence of the judiciary. So you can look at maybe a small heading, just right, the independence of the judiciary, and how we can be able to ensure the judiciary is actually very independent. Because sometimes you've heard that maybe some judges have been bribed to maybe make certain rulings. So how do we ensure that the judiciary is actually very independent from actually being influenced by maybe those particular parties in making certain rulings? So you can write a small heading and say the independence of the judiciary, which is actually one of the arms of government. So the independence of the judiciary. The independence of the judiciary. So I just say the function of the judiciary, the function of the judiciary is to administer justice, and operate impartially in an unbiased manner, So it shouldn't actually be biased in making its rulings or judgment. So the independence of the judiciary can be ensured by the following. So how do you ensure independence of the judiciary? So the independence of the judiciary can be ensured. The independence of the judiciary can be ensured by So number one, what do you do to ensure that there is independence of the judiciary? So by number one, by providing security of tenure for judicial officers, for judicial officers. So you basically come up with maybe contracts as to what is actually maybe their terms of service, how long they are going to be able to serve, maybe in a particular office or rank, maybe in the judiciary. So by providing security of tenure for judicial officers, providing security of tenure for judicial officers, ensure economic independence or adequate funding of the judiciary. So ensure economic independence, or you can call it adequate funding of the judiciary, So they shouldn't be seen as like beggars who are basically begging for money from the government. So they should be funded adequately to ensure they're actually able to carry out or run their activities. So ensure economic independence or adequate funding of the judiciary. It should be funded adequately, or adequate funding of the judiciary. So that is actually very important. So we've seen sometimes back, maybe the Chief Justice is complaining that the they are not getting enough financial support from the government in terms of budgetary allocation. So they are not actually able to carry out maybe their mandate or carry out their duties. So it becomes very difficult for them. So another way is to ensure there is the appointment of persons of unquestionable professional and moral integrity. So ensure appointment of persons, ensure persons being appointed. So ensure appointment of persons, ensure appointment of persons of unquestionable, appointment of persons of unquestionable moral, or let's say professional and moral integrity. Unquestionable persons, ensure appointment of persons of unquestionable professional and moral integrity. So persons who have high integrity, so they have been proven according to maybe their work history or maybe how they carry out themselves as persons of integrity or moral integrity or basically professional integrity. So they follow the requirements of the profession in terms of executing their mandates as maybe judicial officers. So when you appoint the judges, ensure they are of unquestionable or professional moral integrity, to ensure they are not actually influenced or maybe bribed by any person to make a particular ruling. So they make their decisions independently as per the requirements of their profession, So another way is to ensure, number 4, another way how you can ensure the judiciary is actually very independent is to ensure there is what we call immunity from court action, immunity of judges, immunity of judges, from court action, immunity of judges from court action, immunity of judges from court action, taking place in the course of judicial proceedings, in the course of judicial proceedings, So that is basically how the independence of the judiciary can actually be ensured. So that's how basically you can actually be able to ensure the independence of the judiciary, So we can look at something else in relation to this. So it is known as natural justice, or the principle of natural justice, the principles of natural justice. So the principles of natural justice. What we mean by natural, is basically being in accordance with the determined or determined by nature. So based on the inherent sense of right or what is actually right or wrong. So natural, by natural we mean natural means, you can say natural simply means being in accordance with nature, or what is actually expected, what is actually quite obvious, being in accordance with nature, with nature, or best, or basically you can be able to say i.e. So that is we mean best, best on the inherent sense of right and wrong, based on the inherent sense of what is right and wrong. So what is the nature, or what is actually the expectations in this case? So if you look at the expectations, so if you go astray, it basically simply means you've not actually basically acted as per the requirements in terms of nature. So what is actually expected for you to in this particular case or in this particular scenario? So you have that particular sense of being able to know that if I do a particular act or do a particular thing, then it will basically either be right or basically it can actually be wrong. So when you talk about being just, so there's that particular other word, justice. So just simply means that morally upright, correct, proper, or maybe good, or maybe actually merited. So you can be able to say just means morally upright. So morally upright, it means morally upright, correct, can maybe be correct, or maybe it can be good. Morally upright simply means just simply means morally upright, correct, proper, good, or sometimes we can say or merited. So so when you talk about, in this case now, natural justice, we simply mean it is simply the maintenance or provision of observance of what is actually right, or what is actually basically right. So it is the observance. So natural justice is the observance. So now natural justice is the observance of what is right, or expected. So if you're actually able to observe what is actually expected of you in a particular society or maybe a particular place, then we'll say basically you are behaving in a just way, or basically you can be able to say you are basically applying or ensuring you basically comply with the principles of natural justice. The principles of natural justice is where now you're actually able to observe what is right, or we can say what is actually just, what is right, just, proper, or correct. What is right, proper, you can say what is right, just, proper, or correct. So that's what I mean by natural justice. So there are certain principles that are actually basically can be applied maybe in courts of law to determine as to whether maybe a particular ruling was actually just or not. Was it actually correct or not? So certain principles might actually be applied. So when we talk about principles now, they are simply rules that will be able to govern procedures of conduct of administrative bodies as to how they are supposed to conduct themselves. So from these particular principles of justice, then you can actually be able to determine whether a particular administrative body actually acted maybe out of or beyond their powers, or maybe they acted without having to consider whether their act is actually just. Exactly just. By just we mean whether it is actually correct, or wrong to the party. Maybe that particular act is being done upon. So the principles of justice or principles of natural justice are simply rules that basically try to determine or give the procedures of the determination as to how administrative bodies should actually be able to conduct themselves or carry out themselves. So we have several of them. So most of them were actually borrowed from the common law. So the principles of natural justice. So in this case, we are saying that, for example, if you are an accused party, before the court. So they'll give you certain rights. So those are the ones we call principles of natural justice. For example, in this case, they'll be able to ensure that you have a right to be heard. So in each and every court, any court of law, before basically the case actually proceeds, they'll basically try to ensure they have given you the right to be able to be heard, whichever kind of case. Then you'll actually be notified in advance. So there's what we call prior notice in this regard as to what you've committed as a wrong. So that you can actually be able to build your own defense against that particular case. You'll basically enjoy what we call the rule of not actually being biased upon. So the court won't actually be biased in any way. So if they basically is determined later on they're actually biased, then of course you have a right to appeal at a more superior court so that a proper determination can actually be made whereby there won't be any form of favorism to either parties, either the accused, or maybe either the defendant, or maybe the complainant, so that is the plaintiff before the court. So you also have a right to be able to seek for adjournment. So you've been accused before the court. You can seek for adjournment due to maybe certain reasons. So maybe you're not actually able to attend, maybe due to sickness, or maybe you are actually affected, you're actually quite away, so you can't be able to make it. So you can seek for what we call an adjournment. So that is a right that is actually given under the principles of natural justice. Then we have what we call cross-examination. So this is basically whereby you've seen basically, for example, lawyers having to query or ask questions before the court so that they can actually be able to direct the court as to whether what had been committed was actually wrong or not. You have a right to, for example, get a legal representative. So someone to be able to represent you before the court, like an advocate or a lawyer, so that they can be able to give you guidelines or guide you on how you can be able to argue the case before the court of law. You can be able to argue the case before the court of law. So those particular principles of natural justice basically be applied in terms of administration of justice or administrative activities or by the different arms or organs of the government. So they have to ensure those particular principles of natural justice have been applied in all their actions, or in all the actions when they are carrying out their services, when they are carrying out their services. So we can be able to say the principles of natural justice are, the principles of natural justice are rules governing procedure. The principles of natural justice are rules governing procedure, are rules governing procedure and conduct of administrative bodies and conduct of administrative bodies and conduct of administrative bodies and conduct of administrative bodies. The principles of natural justice are rules governing procedure and conduct of administrative bodies and conduct of administrative bodies. Then you can just say they include the following. They include include the following. They include the following. They include the following. So they include the following. They include the following. So what are these principles that will actually be applied? So they include the following. They include the following. They include the following. They include the following. So number one, rule against bias. Rule against bias. So there shouldn't be any form of biasness. So rule against bias, the right to be heard. So the right to be heard. The right to be heard. Prior notice of notice IE, let's say IE, of the wrongs committed, of the wrongs committed, e.g. or IE of the wrongs committed. Then another principle of natural justice, disclosure of information. So right to be able to disclose the necessary information for your protection or maybe defend. Disclosure of information. Disclosure of information. So you have a right to be given the opportunity to disclose what is required before the court. Right to seek for adjournment. Right to seek for adjournment. Right to seek for adjournment. Then number 6, another principle of natural justice, right to cross-examination. Right to cross-examination. Right to cross-examination. As I've explained, this one is basically where now you see a lawyer giving out queries to the other party so that he can be able to build up evidence to protect his clients. So you'll be able to ask several questions or cross-examine maybe the defendant or the plaintiff before the court. Then a right to appoint a legal representative. So right to appoint, like a lawyer, right to appoint a legal representative. 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 So those are some of the principles of natural justice that will basically be applied by any administrative body. So like any body may be under the judiciary, under the executive or legislature, in trying to execute their mandate under administrative law. So that is what we mean by the principles of natural justice, the principles of natural justice. So if you are accused before the court, you'll get all these particular rights for it to be concluded that that particular ruling or that particular case before the court is actually just, or the principles of natural justice are actually being applied. So that is what we mean by the principles of natural justice, the principles of natural justice. So for example, in this case, if you discover that you didn't get a fair ruling due to this particular fact that these particular principles of natural justice were not actually applied, then of course you can be able, for example, if it is a lower court, you can seek an appeal at a higher court by your argument that you are not actually basically, for example, you are not given the right to be heard. So if such actually arises, then of course it can basically lead to maybe the case being withdrawn from a lower court and being taken to a superior court so they can give out that particular order. So the case be removed from a lower court or a junior court to a superior court so that maybe a proper hearing can actually be had for the determination to be made by by the judge in the court of law. So if these principles of natural justice have not actually been applied, then you have a right to maybe seek an alternative opinion from a superior court, an alternative opinion from a superior court. So you can simply be able to appeal in a superior court for these particular principles of natural justice to be applied, for you to get a fair hearing, for you to be able to get a fair hearing. So that is what we mean by the principles of natural justice, principles of natural justice. So ideally, we are saying if they don't work, you can seek for an appeal, or sometimes we call it a judicial review. Sometimes we call it a judicial review. We call it a judicial review. So let's see if we can be able to get some questions here. Pardon. So there is a question I want to share. I want to share some questions there, just a minute. So there is that particular question there. I hope you can be able to see it is from November 2017. November 2017 is question number 4B. It says, with regard to administrative law, explain the term separation of powers. Explain the term separation of powers. Then part 2, summarize 3 grounds upon which the courts might interfere with the decisions of an administrative body. So grounds upon which the courts might interfere with the decisions of an administrative body. So when you talk about separation of powers, as we've seen, is whereby the organization or basically administration of government functions is actually divided into 3 arms of government, or maybe 3 separate arms of government. So i.e. that is the executive, the legislature, and the judiciary. So that is what we mean by separation of powers. It is where the executive, it is where the government powers are separated. It is where the government powers are separated by its functions being divided into 3 arms of government. Its functions being divided into 3 arms of government. So that is the executive, the legislature, and the judiciary. So each arm of government will have its own functions, unique functions from the other. So that is what we mean by separation of powers. So what are the grounds upon which the court might interfere with the decisions of an administrative body? So we are saying that when an administrative body is actually basically carrying out maybe its mandates or its powers or its functions as outlined under administrative law, then they must be able to apply what we call the principles of natural justice. So that's why we are saying that failure to be able to do so, then of course, you can be able to seek for a judicial review in a court of law. So the court of law will be able to assess as to whether the principles of natural justice were actually applied by the administrative body in carrying out its mandate or functions. Failure to which, for example, if they made a particular decision, then of course, failure to observe the principles of natural justice will basically lead to the court having to interfere with their decision. So if there is the opposite of all these principles of natural justice we've talked about, for example, if it can be realized there was actually bias in a decision of an administrative body, the court will actually be forced to interfere. Number 2, if, for example, a person has not been given the right to be heard, then the court will likely also be able to interfere with that particular decision. Number 3, for example, if this particular person was not actually given prior notice as to what were actually his wrongs or the wrong he had actually committed by the administrative body, then it simply means that that particular principle of natural justice had not actually been applied in making the decision by an administrative body. So therefore, the court will likely be able to interfere. Or for example, in this case, you as the person who faced that particular administrative body can seek for a judicial review in a court of law. So if there is any administrative body that is making a decision or a ruling or it has been given the mandate to make a particular determination, then it must actually always employ or basically ensure it is making the decision as per the requirements of the principles of natural justice under administrative law, failure to which the court can actually be able to interfere. So the opposite of these ones, all of them basically will lead to the court having to intervene and being able to check as to whether the principles of natural justice had actually been applied. So I think that is the last bit we'll be able to look at when we'll be finalizing on this particular topic in our next class before we start the other topic. So we're just remaining with a small bit on this particular topic and start the next one. So maybe we can look at another question. Let's see if we can get another question. So we can look at this one. Let's just see. So I hope you can be able to see that one. It's question number 5. It's from which sitting? It's from May 2017. May 2017. Question number 5. Question number 5. So you can look at 5A. 5A, B, and C. I think this is just what we've covered. State 4 ways through which the independence of the judiciary might be actualized. So that is what we've just written here a few minutes ago. How can the independence of the judiciary actually be actualized? So ensuring there is economic independence. So the judiciary doesn't actually depend a lot or looks like a beggar to maybe the executive. Ensuring there is a security of tenure for the judicial officers. Security of tenure for the judicial officers, to ensure they're actually immune from any judicial actions or court actions while they're actually basically carrying out judicial proceedings. So in the middle of judicial proceedings, they shouldn't actually basically be put under court actions for any wrong that has been committed. So immunity from actually being accused before the courts. So another one is actually, we said that ensuring people of integrity, professional and moral integrity are actually appointed to serve as judicial officers or judges. So with that, you can be able to actualize what you are calling judicial independence or judicial independence of the judiciary. Explain 3 advantages of the doctrine of separation of powers. Separation of powers. So it leads to, you can be able to say that it makes the arms of government be accountable. It makes the arms of government be accountable because there are always checks and balances from each and every arm of government. It avoids power basically being concentrated in one arm of government. So it basically ensures there is no actually abuse of power, whereby power is just concentrated in one arm of government. So it also ensures that the proper functions, or basically the functions of the government, are actually properly executed by the different arms of government. So the executive will be able to know its functions and as to what are their requirements or expectations under the separation of the powers, So highlight 3 disadvantages of case law as a source of law. So I think this one we've just looked at a while ago. So highlight 3 disadvantages of case law as a source of law. We've said you can call it case law or judicial precedent. And this case we are saying is whereby judges are making references to past rulings, how they were actually made, and they make similar or same rulings. So you said number 1, what is actually common there is there's an aspect of rigidity. So it makes the court systems become very rigid. So they don't basically think in a different way. So they basically make almost similar rulings. They make almost similar rulings. It is sometimes bulky and very detailed. So judges have to do a lot of reading and references backward so that they can actually be able to see whether they can be able to maybe employ or basically deploy previous rulings as current rulings. It is backward looking in nature. It is not actually future focused as a source of law, because you are basically just making references to the past ruling. So it doesn't look at the circumstances that are actually current. So maybe there has been change of technology. So you can't make the same ruling over and over again over the years. Several things might have actually changed. So it is backward looking in nature. It doesn't provide solutions that are actually very current and basically for future expectations. So case law as a source of law is a backward looking source of law. It doesn't look at the future or maybe current circumstances. There's that part D. So maybe that one I can give as an assignment. You go and actually check what we learned about presidential assent or the process of presidential assent and maybe legislation. So when the bill is actually basically taken to the president, what actually happens at that particular stage where the president has been given the bill. So maybe just to highlight, so the president will actually get this particular bill from parliament. So that is the final stage for presidential assent. So what will happen during that particular period is that the president can actually be able to look at the bill. So when I mention a bill at this particular point, you should actually be able to know it is a proposed law that has basically undergone all the stages in parliament and is basically just awaiting to be assented to or signed by the president to become a law or become an act of parliament. So when it has undergone all the stages in parliament and goes to the president might actually be able to do some few things here and there. So number one, what will happen? He can be able to assent to the bill without having to do any amendments to the bill. Alternatively, he can be able to make certain proposals to be included in the bill and send it back to parliament to be discussed. So he can either assent to it or sign it into law, or make amendments to it and send it back to parliament for further discussion, so that parliament can be able to assess and look at the amendments by the president, and maybe after they checking it, they can send it back to the president for assent. If the bill is actually okay, then the president will actually go ahead and actually sign the bill into law. Or if he fails to basically, so this particular signing must actually happen within a period of 2 weeks. So failure to sign the bill within a period of 2 weeks, it will be presumed that the bill has actually automatically become law and the president has no option but basically to sign it. So it simply means that if it is to return it back to parliament, it has to happen within that particular period of 2 weeks. So if it elapses, then of course the law will automatically become an act of parliament. The president would have an option but basically to sign it or basically assent to it. So that is what will happen during the presidential assent of a bill, or actually a proposed law from parliament, So that's how basically they can be able to test. So maybe bring questions with regards to maybe that particular topic. So I think today we'll end there. So unless there's a question, you can be able to pose the question at this particular point. But that is the end of our class for today. So until next time, that's when basically we'll be able to meet and maybe proceed with this particular topic, and of course start. So we'll be able just to wind up a small bit and start the next topic. So I don't know if I had promised to send the notes, so I'll be able to do so probably by, let's see if I'll be able to have finished compiling them by weekend. Then I can be able to send, but I'll be able to send the notes. I don't know if a link has been shared for the past papers. So that one, I think I can be able to share it right now. Can be able to share it right now if it hasn't been shared. So is there any question from, I can see I can see Sasha. Sasha, are you here? Oh, it seems Sasha's internet has a problem or what. I can't hear Sasha properly. So I think the past papers were actually shared. I can see someone shared them there. I can't get Sasha properly. I don't know, it's internet or network problem.
I'm here. My network is low, so
yes,
that's why it's pushing me away every now and then. But
oh,
it is
okay.
most of the things.
This is your first class?
No, it is not.
It is not, huh?
Yeah.
So do you have a question?
No, not for now.
Not at the moment. Huh?
Yes.
So it's okay. So I think I don't know if there's any other person. I can see Bernard. Bernard, are you here? I can see Bernard. Bernard, are you there? Yes, Bernard. Bernard? I don't know if I can't get Bernard. I haven't gotten Bernard, but it's okay. I can see Anthony. Anthony, are you here?
Yes.
Anthony, do you have a question?
Maybe a question is on the disadvantages of case laws.
Yes.
You said it can be rigid.
It can be rigid,
Then we said it's backward looking. Can that be one point?
Basically, what we mean by rigid is it's when basically like all the judges think in the same way, in a straight way. So they don't think outside the box. So there's no way you can actually be able to imagine that facts in all the cases that are coming before the court will actually be similar. So they'll just be like rigid. They'll just be not be thinking outside the box, because I can't imagine that cases will actually be similar for maybe over like 50 years. Several things might have actually changed. So it simply means that they don't think out. When you mean by rigidity, we mean that they don't think outside the box. Simply because, as to what I've said, there's no way the facts will actually always be similar for you to come up with the same rulings. So you must actually be able to think beyond, not just being rigid and being straight. That once it is like this, it must remain like this. You can't bend, you can't do anything, so you just have to go like this. So it makes them not to think. Judges won't actually be able to think outside the box. So they'll actually just like be not even having, they don't even think of looking for an alternative solution to a problem. So they'll make similar rulings. They'll become very rigid. They think straight, in a straight way. So that is what we mean by rigidity. By backward looking, it basically means that, let's say, for example, if you look at, for example, a ruling that could have actually been made in terms of, let's say, for example, communication, like 100 years ago, 50 years ago, it might actually not basically be similar to what will actually happen currently, because several things have happened, have changed. Like currently, there's maybe happening of technology. People can actually be able to communicate in different ways. So for example, if there's an argument before the court that you didn't actually get information, maybe sometime back, like let's say, for example, 50 years, maybe information could take maybe 10 days to reach out to you. So currently we have mobile phones. So there's no way you can argue before the court that maybe you didn't get certain information because there was no any other means apart from maybe use of postal office, because there's actually technology. So a ruling that had actually been made in regards to the same thing in terms of, let's say, for example, effectiveness of communication 50 years ago, it might not actually be the same. So you can't actually basically be thinking like backward, thinking like things are actually just the same. Things are actually basically evolving. So what actually used to happen, like let's say, for example, 10 years ago, might not actually be the same. So if you basically rely on case law as a source of law, it simply means that you are basically thinking of the past. You're not actually basically looking at what is likely to happen in the future or what is actually happening currently. it is quite obvious that what is even happening now might not actually be the same as to what will happen, let's say, for example, next year or maybe a few years to come. So as you make the ruling, basically it simply means that if you rely on case law, you'll just basically be looking at the past, not considering other factors that are basically like looking into what is likely to happen in the future or what is actually happening currently. So I hope you've gotten the difference. The backward looking is basically you think of the like what happened 20 years ago. You don't think of the current situation or circumstances. Rigidity, you think in a straight way. So there's no way you can bend or you can't, basically you can be able to say you can't think outside the box or think in a different way. So that is what we mean by being very rigid. So I hope you've gotten my point.
Yes, I have.
Okay, sawa. So I can see Tenai. Tenai, how are you? Is Tenai there?
Doing good.
Tenai, do you have a question?
My question was about the doctrine.
Doctrine of separation of powers.
Separation
Yes.
of powers. Yeah.
Yes.
So you say at some point you say no person should be a member of more than one organ. But in some scenarios you just get there to like somebody's in executive and someone is in parliament. So is that point really valid or?
Okay, you see what I said. You see this guy, this particular doctrine you are saying, it was developed by a French jurist long time ago, known as Montesquieu. So this guy, according to him, what he was actually proposing, according to him, what he wanted when he made the proposal, this particular, after doing a lot of research, he made the proposal. He's basically proposed that no person should actually basically be in two different arms of government. But in reality, that can't happen. So that's why we even said there's another proposal he actually made that these particular arms of government should actually be completely separate, such that there's no way a particular arm of government will depend on the other. But that can't actually happen in reality. In reality, what is actually happening, even though we have the different arms of government, see, basically led to that particular development of the separation of powers, some of these proposals can't actually happen in reality. So you might find that, for example, there is actually maybe like the Attorney General. So maybe basically we say, for example, he sits maybe in Parliament and also on the executive. So it can't actually basically happen in reality. So although these arms of government must actually be able to operate independently somehow, but they can't operate in a glass ceiling whereby there's complete separation. There's actually interdependence somehow, because in this case, let's say, for example, you find that judiciary basically depends on budget. A budget is normally actually prepared by Parliament and the executive. So that was actually basically just a proposal by Montesquieu. So it just basically led to the development of the separation of powers, although his proposals, some of them can't actually exactly happen in reality. But of course, what normally happens, these arms of government, even under the law, we are told that they must actually be able to operate independently, but they can't operate in a glass ceiling. They'll somehow depend on each other. So those particular proposals was by Montesquieu. But you are saying in reality, it can't happen. So you can't basically completely shut off and say that no person is basically supposed to be like in Parliament and not actually basically in the executive. So I hope the main point by Montesquieu was separating the powers. You can see separation of powers, because you are saying if you give the assumption that, let's say, for example, all these powers, the executive is making laws. The executive is basically administering matters to do with justice. The executive is the one that is basically carrying out other activities, let's say, for example, preparation of budget and everything. This means that powers will actually basically be like in one arm of government. So as states, if it actually operates like that, then it simply means that things might not actually be okay. So there might be like dictatorship. You find that the president just wakes up and says that this particular law has been changed. You find the president wakes up and says that this particular person, they have made a ruling that is supposed to be jailed. But of course, as a result of that particular separation, then there's no way a person will actually be jailed without having to go to court. there's no way basically a law will be implemented in the land, or let's say, for example, Kenya as a country, before it goes to parliament. So the president, even if he proposes a law, it has to go to parliament. It goes through the process. So that is the arm that has been given the mandate to make laws. The judiciary, administration of justice. So if there's any person who has committed a wrong, he must actually basically be taken to the courts. He must be heard so that justice can be administered. So to avoid concentration of powers in one arm of government, then he proposed that particular separation. But of course, some of his proposals, they can't completely happen in reality. So due to certain challenges here and there, so they can't operate completely independently. Hope you've gotten my point.
Yes.
So
my second question was, it's not about the class. I'm
your
attending
second
my
question
first
is?
class today.
Your
I'm
second-
attending my first class.
Oh, this
My
is your
first class is today.
This is your first class?
Yeah. Yeah, so about the previous classes.
Okay, I happen to have recorded them, so maybe I don't know how you'll get them. I think the studio guy, maybe I talk to him, then you try to reach out to me. I see if we can be able to share the other recordings, but I've recorded all of them from the start.
Thank you.
So I wish you guys a good night. I think we'll meet next time.